Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In this episode, we consider the Labour Appeal Court's recent decision in Golden Arrow Bus Services versus CCMA and others, involving the dismissal of an employee, where the CCMA found the dismissal to be substantively unfair but declined to order reinstatement. The Labour Appeal Court upheld the Commissioner's refusal to reinstate the senior manager on the basis that a continued employment relationship would be intolerable. We explore what intolerability means under Section 193, subsection 2 of the Labour Relations Act, which provides that reinstatement is the primary remedy except in the following four circumstances. A. The employee does not wish to be reinstated. B. The circumstances surrounding the dismissal are such that a continued employment relationship would be intolerable. C. It is not reasonably practicable for the employer to reinstate or reemploy the employee. Or D. The dismissal is unfair only because the employer did not follow a fair procedure. Welcome back to another episode 19, and only one more episode till our finale for the season, and we officially end off season 1. But Debbie, how has your week been and your return to the academic semester been so far?
Yes, an interesting and busy start to the academic semester and term 3, but looking forward to our discussion today.
And on that note, let's jump right into the first question. Debbie, what are your thoughts on the Labour Appeal Court's approach in this case?
So, Aisha, as with several of our previous discussions, it's the timelines in the resolution of these disputes that comes to mind. This was a curious incident going back to October 2018, and it's taken until June 2025 to get the Labour Appeal Court decision and an ultimate decision in this matter. There's been a pandemic in between. This involves a bus company, Golden Arrow, which of course would have been thrown completely off track during the pandemic. No doubt, well, perhaps not, but employees may have been retrenched or put on short time, and yet the decision is a retrospective reinstatement. So I think there are a lot of considerations that come in with timelines, and of course in the decision itself, a lapse of time is not a reason not to reinstate an employee, and those decisions, those intervening circumstances are not considered in the judgment, but reinstatement, of course, was not awarded. So in this case, we have an employee, Kevin Jacobs, who had 26 years of service, an extensive period that he had worked. He was, at the time of his dismissal, a support services manager who was responsible for the rollout of a new automated fare collection system, a smart card ticketing system, which was scheduled to roll out on the 15th of October in 2018. And curiously, he goes on leave on the 11th of October to return to work on the 18th of October. So the date of the rollout in slap bang in the middle of his leave period. And when he comes back, there has been a crisis, including a number 18,000 missing smart cards, which is just one of several problems during the rollout. Nothing more is made in the decision of these missing smart cards, but it does raise questions around the facts and what unfolded here. Ultimately, he was... the CCMA found that dismissal was too harsh, that he had been negligent, but this was not deliberate fault on his part, but rather negligent conduct, and that his dismissal was harsh, and that he had been unfairly dismissed, ultimately awarding him 12 months in compensation. And, the reasons for not reinstating Mr. Jacobs is that he had been in a relatively senior position. There had been a breakdown in the relationship between him and the operations manager and the IT department. And although his view was that reinstatement would be tolerable, the CCMA commissioner found that there had been much relationship damage. As a result of his failure after returning to work, his failure to cooperate and to find solutions, he, on the other hand, had an interesting reaction, and he felt that he could not trust his own senior management. He felt that evidence had been destroyed that would have assisted him, that the employer was biased against him, and that he had been set up to fail. So this is all very curious behavior by somebody who, up until this point, appeared to have given 26 years of good service. And for me, this raises questions also around the process that may have been followed. Is this an issue of poor work performance? Was he being supported in the role? Was there a health issue? But this is not raised in the judgment. And I'm merely, giving you my reaction. You asked what were my initial thoughts. So the commissioner felt that his assertions in these regards was not supported by credible evidence, and that he had a long-standing good working relationship in any event with his manager. and rather found that he had failed to accept the responsibilities that came with his contract of employment, and that there was no evidence to show that his approach to his obligations would change. Yet, his 26 years of service up until that point is not factored into the discussion at this point. So it does seem a little bit odd, and as if there's perhaps a bit more at play. But again, we always recognize in our discussions that we don't have all the facts before us, and we rely on what is in the judgment. In any event, the Labour Court on review, and it was the employee here, Golden Arrow, taking the matter on review, avoid having to pay the 12-month compensation. The Labour Appeal Court actually disagreed with the Commissioner and held the reinstatement should in fact be awarded, substituted his award and reinstated the employee retrospectively into his position. This retrospectivity also maybe raises some concerns, especially with the intervening pandemic, and whether or not he would in any event have retained employment on the same terms and conditions throughout that period. So that perhaps raises some issues, but nonetheless, the Labour Court found that the Commissioner's reasoning was illogical, that he should not have relied on seniority and attitude to the investigation to deprive the employee of reinstatement, because really what ultimately was required was to show that the employment relationship was intolerable, and that this had not been provided before the Labour Court. The Labour Appeal Court, on the other hand, when the employer took the reinstatement on appeal, the Labour Appeal Court confirmed that reinstatement is the primary remedy, and found that there is a high threshold to demonstrate intolerability in order to frustrate reinstatement. But nonetheless, the Labour Appeal Court was not prepared to uphold the reinstatement order, and substituted the order of the Labour Court with that of the Commissioners. So it's an interesting decision, and it raises some issues for me. Your views, Aisha, on the decision in the case, and particularly in the context of the work that you've done. You've written about the many shades of intolerability in the workplace. In your view, what should we take away from this judgment? What are the factors that would determine intolerability, and what is the role of an employee's seniority and their roles and responsibilities in shaping outcomes?
Yeah, thanks, Debbie. I mean, I think you've given a very comprehensive overview of the three judgments, essentially the award, the Labour Court's judgment, and then, of course, the Labour Appeal Court's judgment. I think in this instance, I mean, like I said in our previous podcast episode, we did discuss intolerability and the threshold of intolerability, and we'll definitely leave a link, Prof. Rochelle Leroux and I's article on intolerability. But I think the important thing about this Golden Arrow case is, first of all, I would say it doesn't set a new precedent when it comes to intolerability. What I think it does is that it certainly reinforces how intolerability is actually assessed. And I think just to locate it properly, there are three contexts for intolerability. And I mean, looking at it is the definitional context. So, for example, in our constructive dismissal cases, but from the onset, this does not apply in this instance. And then we look at it from a disciplinary context, and the focus is usually on whether there was misconduct and if this misconduct actually justifies dismissal. And I mean, in this case, here we have Mr. Jacob, whose dismissal was actually substantively unfair. And this typically involves a consideration, again, was there a breach of trust? And although the breach of trust is not absolutely an indicator of intolerability, dishonesty still comes in many shapes and forms. And I mean, in this instance, again, this context, looking at it from a disciplinary context, that falls away too. So I think the main focus was the core issue, which was the remedial context, intolerability as a hurdle to reinstatement. And I think what the court did is that they reiterated the Constitutional Court's decision in Boy, made it clear that this threshold of intolerability is very high, and that, there wasn't this finding of gross misconduct in this case, but rather what the focus in this case was that we looked at the post-dismissal relationship and how this actually played out and whether this was intolerability. But I think what mattered most was Mr. Jacobs was a senior manager. It was his seniority. He was expected to resolve this issue. Those 18,000 cards, he was supposed to try and look for a resolution in the moment. And I think because of his disengagement, I think this ultimately led to this breakdown of this operational trust, which made it seem very difficult to actually have reinstatement. So I think, one could say that even though there was no gross misconduct found and his dismissal was substantively unfair, I mean, again, as you mentioned, he was also awarded maximum compensation, which was obviously overturned by the Labour Court. I think it suggests that an employee's behavior, that does avoid accountability will always contribute towards a finding of intolerability.
You're listening to the Labour Justice Barometer, and we'll be right back.
So So Asha, do you think that the decision in the Labour Appeal Court will influence how intolerability is interpreted, but particularly in cases where the employer fails to prove misconduct but still opposes reinstatement? It raises some difficulties. What are your views on this?
Yeah, I think it definitely does. I mean, like I said, I think this decision, I wouldn't say it would change anything or wouldn't bring anything new to it. I mean, this is obviously a very sound reasoning in the sense that the judgment still reaffirms how intolerability is interpreted. But I think what the LAC reaffirms is that reinstatement isn't always the primary remedy when it comes to substantively unfair dismissals. And I think this this backing on weighty reasons and tangible evidence, this has to be shown when it comes to intolerability. And I think this is what the court reiterates, that intolerability shouldn't be found lightly. And it reiterates this high threshold. And what this case actually confirms is that an employee's conduct during and after the disciplinary process, like I said prior, is that particularly their willingness to cooperate, I think, can heavily weigh on whether reinstatement is actually considered. So I think even in the absence, like it was in this case, of proven misconduct, an uncooperative attitude or a breakdown in trust or complete disengagement might just tip the scale against reinstatement if the evidence supports it in that way. And I think it obviously reiterates this high threshold of intolerability.
Yeah, I mean, I think in this case, Aisha, the employee, although we're sympathetic to the extent that he has lent his service, that the nature of his misconduct, is categorized as negligence, but in reality, he had failed to ensure proper oversight of the internal audit processes and the procedures that were in place, which he should have done, before going on leave. And he did show, a resistance and a reluctance to take accountability for his actions or for the, his responsibilities in terms of his role with the employer. So to that extent, as well as his inability, it seems, to engage constructively around how the rollout, was flawed. He refused to cooperate with the investigation, for example, into the missing smart cards, and he claims, that evidence has been destroyed. So all of this does, is certainly very suggestive of a breakdown of a relationship, which makes sense in terms of the Labour Appeal Court's the outcome of the case. Aisha, that leads us to our question, of course. How would we rate this judgment on our Labour Justice Barometer? Over to you on this one.
I think it's we haven't answered this question in a very long time in our podcast episode. So I think, I have to say that, again, what you mentioned from the start, the timelines for the decision are a major factor to consider, that, it took almost 7 years. And of course, there was a pandemic in between, in case anyone forgot, that, this was obviously something that factors into it. And again, he was a long-standing employee, 26 years. And then, of course, on the other hand, the employee's conduct undermined that trust. He was disengaged, and his response contributed to the breakdown in the trust in the relationship. So I think there's two sides to this, like you said, and I think that's what means that the needle is just sitting in the orange. I don't know, Debbie, do you agree with that?
Yes, I agree with you, Aisha. And actually, what I failed to share with you when you asked your first question, what were my initial thoughts? One of my initial thoughts was also that I'm quite grateful not to be a commissioner or a judge faced with factual scenarios as we find in this case. And I agree with you. It leaves us with a sense of discomfort in terms of labour justice with a needle sitting in the orange.
And I think that brings us to the end of the episode. Thanks again, Debbie, for another great discussion on the topic of intolerability. And to our listeners, if you've enjoyed listening to our episodes so far or have any thoughts on the topic of intolerability and how it's applied in practice, we'd love to hear from you. So please feel free to leave a comment on this episode.
Thanks, Aisha. Thanks again for a great conversation. And until the next time. This podcast is not intended to constitute legal advice.